This one you have in front of you.
Yeah.
House Bill 556.
Okay, thank you, Mr.
It's the
Chairman.
cannabis bill.
You have a reprint of the Cannabis Reform Bill, House Bill 556, with consolidated amendments included. What we typically do in ECM for very large bills like this is to go through the reprint page by page and show you where things are changing. There are quite a few changes that are quite simply technical that were requested either by staff or by primarily the ATC or the Maryland Medical Cannabis Commission that are just making mechanical changes, but we'll go through those. There are changes on pages 1 through 3 of the reprint that are only 1 through 5 of the reprint, actually, that are just technical to the purpose paragraph, the function paragraphs, and adding a renumbering function on bill page 4. The bottom of page 4 of the bill, you see the definition of cannabis moved up from Division 3. That's because the term is used in Division 1. Okay, the next provision on bill page 5, following line 2, a provision requested by ATC and Maryland and the Cannabis Commission, saying that a provision of Division 3, that's the new cannabis law, prevails over an inconsistent provision of Division 1, which means the general language on state alcohol regulation. On bill page 8, the first change of substance in the bill, under current law, the executive director of the Alcohol and Tobacco Commission, who serves at the pleasure of the governor, must be a sworn police officer with law enforcement powers. The change here is to say that he may be a sworn police officer with powers granted, and then there are conforming changes later that will address the pension system as to whether the actual occupant of the office is a sworn police officer or not. The next bill, page 9, there is simply, this is within the Office of Social Equity, rather than charging it with working with the commission, since after all it's under the commission. It's going to work with the Cannabis Regulation and Enforcement Division to implement free technical assistance for social equity and minority cannabis business applicants. This is particularly important preceding round 1 of the rounds of lottery for license. Starting at bill page 11, this here is in the new advisory board. The advisory board on medical and adult use cannabis, and what the changes here, they changed the, actually adding representatives rather than having 3 representatives who hold a standard license and 3 representatives who hold a micro license. You actually have 2 of each category of regular standard and micro licenses. Okay, bill page 12. That simply says that to the extent that those licensees are in classes that don't exist yet, those terms become effective when the when those rounds actually occur. On bill page 13, line 20, we actually add, this is a technical change, but it adds cannabis to the enforcement powers of the Field Enforcement Division relating to cannabis provisions in the business regulation article. This comes up if you have somebody trying to sell illegally at an unlicensed shop or out of their trunk. It corresponds to the authority that they have for alcohol. Okay, bill page 16, some technical changes. We define the Office of Social Equity, and then we make sure that it is the office rather than the full commission that administers the Social Equity Partnership Grant Program. On, let's see, bill page 17. This is the conversion fee. Sorry, this is the, where we're asking for qualifying partnerships for existing licensees to mentor new entrants. They can, under the bill as drafted, they can count the cost of the license conversion fee against the, essentially they can cut down on the cost of the license conversion fee as long as they are doing some mentoring. This is actually saying that it is going to be a maximum of $250,000 per year per qualifying partnership. And the other changes here are technical. Getting down to page 19. In the definition, this is in the new division, Division 3, we define cannabis registrant. And at line 17, we're specifically striking delivery service from cannabis registrant. That means that they're not going to be, we're not automatically adding delivery services here within cannabis registrant. That's going to be handled separately under the micro-dispensary licenses. On bill page 22, there are a number of changes requested by the Cannabis Commission and the Medical Cannabis Commission and the ATC. Some additional language concerning control for purposes of ownership. Next, that's in following line 7. And then what we also do at line, the definition of dispensary, starting at line 11, striking repackaging and transferring from the authorization of a dispensary. We don't want them to be repackaging, doing pre-rolls in-house. We don't want them transferring. Those are separate functions. And then finally, on this page, starting with line 18, the definition of disproportionately impacted area. There was sort of a placeholder here, but what we're saying now with some additional research, it's a geographic area identified by the Office of Social Equity that has had above 150% of the state's 10-year average for cannabis possession charges as determined by information from the Administrative Office of the Courts. Apparently we've had, all the while for many years, information coming from the various courts was inconsistent. Starting with 2010, they've had consistent data reporting through the court system, and that will be used for determining those charging stats will be used for determining what is a disproportionately impacted area. Let's see, page 23, a couple of changes. Line 5, we strike distribution from the authorization of a grower. After line 14, we define an institution of higher education. It basically parallels that in the education article. So for purposes of protecting researchers, it will mean any institution of higher education. For purposes as we use it in the social equity licensees, it will have a more specific application, as we'll see later, for a 4-year institution. And then finally, the bottom of the page, after line 23, suggested by the Medical Commission, definition of passive investor, and then that is used for purposes of determining, again, control for and ownership restrictions. On page 24, after line 18, this is exactly where we get the, in the definition of social equity applicant. This is an or. Under the bill, they have to have lived in a disproportionately impacted area for at least 5 of the 10 years immediately preceding the submission of the application, or attended a public school in one of those areas for at least 5 years. And the criterion that we add is to say they attended for at least 2 years a public institution of higher education in the state. It's actually a 4-year public education institution in the state, where at least 40% of the individuals who attended are eligible for a Pell Grant. Essentially, that's the HBCUs plus UB. Okay. Bill page 25, we slightly rework how the Cannabis Regulation Enforcement Division is situated within the commission. Rather than reporting to the executive director of the commission, it'll be an independent unit that functions within and then reports directly to the full commission itself. And again, the director of that division is the one who is appointed directly by the governor with the advice and consent of the Senate, serving at the pleasure of the governor. One thing on bill page 26, the tasks that the division has to do, since the referendum, since last year's law and the referendum that passed authorized home possession for home grow, basically. What this does is it requires the division to develop a process for consumers to actually purchase clones and other materials that they can use for propagating in accordance with it provides a citation to the criminal law article, but that's actually the authorization for home grow. Obviously, it's not home grow for distribution, it's home grow for home use. So that's on bill page 26, following line 16. Correct. We call it item 3, A3. Okay. Next items, again, some minor stuff here. Bill page 29, following line 10, there was some concern that there are going to be emergency regulations that are required from the division to do all of this regulation, and they do have to come in with non-emergency regulations by July 1 of 24. What happens if that slips? We wanted to make sure the regulations stay effective. So once AELR signs off on the emergency regs, they will stay effective through the taking effect of non-emergency regulations, which we hope should be in place by July 1 of 24. Knowing the AELR process, that usually happens, but there are times it doesn't. So, and I can tell you that from personal experience, having staffed that committee. And then finally, after line 13 on this page, things that the division has to do by non-emergency reg are to adopt regs requiring licensees to transition from a cash system to use traditional banking services, and we deal with that later in the bill, but also to establish trade practice restrictions. This is similar to what happened when alcohol was transitioned from a tied house system to a more competitive three-tier system where you have independent tiers. You can't have the manufacturer or the distributor stocking the shelves, for example. And you have to make sure there's shelf space available for products from processors and growers that are not affiliated with the dispensary. That's also going to be particularly important when you have to have shelf space available for the products of micro growers who may not be tied into their own shop. So that's page 29. On page 30, this is in the provisions regarding the independent state testing lab. In addition to testing cannabis, if this lab is being set up for the renamed ATCC, it should also be able to identify the presence and purity of cannabis, alcohol, and tobacco in samples or seized contraband to support the regulatory authority of the commission. One of the reasons we were setting up a state lab for this is because while there are existing facilities within Ag and the Department of Health, is because Ag and Department of Health also participate with some federal programs. And there are still federal restrictions on cannabis. We wanted to make sure we have a state facility that does not have its hands tied. Okay, next changes are on page 36. This is something that was implicit. They figured they should make it explicit that when you have licenses that are converted, not only do they pay the conversion fee, but they also have to comply with the ownership restrictions that are in the bill. So, okay, page 39 of the reprint. Okay, actually, following line 4, we talk about certain restrictions. Those same restrictions don't apply to someone who owns an ownership interest only as a passive investor. That's language that was suggested by the Medical Commission. On the same page, following line 15, are two new subsections. G says that a license issued under this title is not property and does not confer property rights, and it's subject to suspension, revocation, restrictions authorized by law, and the regulations authorized under the article. That is verbatim from the language that we use for licenses for alcohol that are issued. So this is making sure that you're not, this is a privilege that you are being granted by state license. Also, we say that for those holders of a prior license from the medical commission. If you don't want to convert the license, you can't operate after July 1st, and you can't renew, but you can hold the license for resale to another person for conversion. And if you do that and you resell that license, then the person who purchased it and converts it has to pay the conversion fee. On page 40, this is canopy restrictions. You have an ability to, under the bill, to expand canopy based beyond your existing canopy. However, you can only do half of it for January 1, 2024, essentially round one, and then any remaining increase has to wait until after round two of the licenses being issued. On bill page 41, following line 18, we require the division to adopt minimum standards for protected rights of growers and their employees. It's essentially a labor protection provision, recognizing that the National Labor Relations Act exempts agricultural workers, so these are workers who are not able to be protected under federal labor law, but we provide some opportunity for the division to adopt standards that then the licensed grower must abide by. Then we have the conversion fees. The one-time, primarily page 43, following at line 18. The one-time conversion fees may be paid in separate installments, but have to be paid in full, essentially within an 18-month period by January 1 of 2025. And if you pay if you've already paid a renewal fee to the medical commission, that'll be credited towards your conversion fee. That is for all license classes: grower, processor, and dispensary. Sorry, I'm thinking in alcohol terms occasionally. On page 45, the bill as introduced would have had 10 micro licenses in round one and 125 in round two. Rather than trying to get 75 deliverers up and running, the chair decided that that really needed to be a pilot program. So round one, we're only going to authorize 10 dispensary licenses, micro dispensary licenses. Those are home businesses that operate by delivery rather than by brick and mortar store. But we take those numbers and we add them to the second round, which you'll see starting on page 46. So that'll be 190 micro dispensary licenses, should be up to that, should be available in round two. You will see on pages 46 through 48 what looks like an awful lot of strike through and rewriting. This is actually language that was recrafted by the Office of the Attorney General without really making any change in substance, I will say, or at least from the intent of the original drafting. This is more closely to tie the state to what needs to be done to satisfy the Croson decision and subsequent decisions regarding race neutrality in these license rounds. So that's really, page 46 through 49, through the bottom 49. We do allow, starting at the bottom of page 48, we changed local jurisdiction to be political subdivision. It's a very technical thing. Local jurisdiction in the existing alcohol article means a licensing jurisdiction, so that's a county, municipality, or the city of Annapolis. And instead, what we mean is a county or municipality. So we have previously defined political subdivision, and we're now using the term here. There's no change in substance intended there. We do say that they may not, and you get on to bill page 49, they can't, the original bill said they can't impose a tax on cannabis. We actually moved that down a little later on the page. One new thing that we suggest is that locality may not impose a licensing, operating, or other fee or requirement on a cannabis licensee that's disproportionately greater or more burdensome than those imposed on other businesses with a similar impact on the area where the cannabis licensee is located. So, you know, you might have the place where you locate the adult video store, and the cannabis dispensary is right next to it, like on Route 40, near where I live. And you're not going to be charging the one, you know, $10,000 and the other $5 million. So that's the intent behind that. Following line 22, we say a political subdivision or special taxing district, since those are also taxing entities in the state, may not impose a tax on cannabis. On line 25, we are requiring that for those incubator space licenses that are authorized, the ones who will be operating within that incubator space must be a nonprofit entity rather than a for-profit entity in which area which micro licensees may operate a cannabis business. On top of page 50, we also specifically authorize those incubator space licensees to purchase equipment to be shared by other incubator space licensees in the same incubator space. Essentially, this is like a common kitchen. You know, Clarksville Commons, that has that kind of thing where you have a commercial kitchen people can go to and do their food. Well, they'll be able to do this with cannabis, as long as they have the proper licensing. And let's see. Page 55. Most of the changes here, following page 2, line 2 rather, we require that dispensaries, shelf space in dispensaries available for cannabis and cannabis products from growers and processors that don't share common ownership with the dispensary. I mentioned that before. This is, again, the same sort of thing, avoiding the problems we had with tied houses and alcohol, making sure you've got somebody else's product space available. You give somebody else product space. The bottom of the page, we do require a couple of things. First of all, line 23, the division may not deny a cannabis agent registration based on a cannabis-related offense. The bill came in saying January 1 of 23. This is being moved back to July 1 of 23 when cannabis becomes legal. 2 new subsections added at the request of the Medical Commission and the ATC, requiring a cannabis licensee to require each agent to complete every year a responsible vendor training program. And then we also say that if they had an agent registration from the old commission, it continues to be valid and it authorizes them to be employed or volunteer with a licensed cannabis business. But they're still going to have to go back into the training every year thereafter. Technical change at line 26, a person wishing to hold an ownership interest of 5% or more shall submit the division rather than individual, since obviously you can have a corporate or LLC ownership coming in. On bill page 57, these are the initial license has to be held under in the original ownership for 5 years in the bill as drafted. There are things that occur that will require the ability to transfer that license. Those, as the bill came in, said death of the owner. That obviously is something that can't be controlled. The other things that we have to deal with are disability, incapacity, bankruptcy of the license holder, or court order. If you have litigation and the court says you got to transfer the license, we are recognizing that here in the bill. And then finally, we in lines 16 and the following 19, we change the definition of owner to remove stockholder. These are on the particular restrictions against holding an interest. If it's only stockholder interest as opposed to controlling interest, then that becomes okay. Let's see, what else next? Page 60 are primarily cleanup of the compassionate use fund. I talked with counsel at HGO who had done this bill last year or the prior year when they had the compassionate use fund, and also to Director Tilburg. And there was an awful lot of standard language that was not put into the compassionate use language, fund language, and we've put it in. That's essentially all. It looks like a lot of change, but it's just making it look like every other special fund in the state, pretty much. And then we also, on page 61, we need to make sure that those academic research representatives who are getting cannabis for federally authorized research, they are protected as well as every other researcher. So they can do that and not be prosecuted. Let's see, what else we got? On page 68. Okay. Following line 27. This is a restriction. These are prohibited acts. What can a dispensary not do? By amendment, they won't be able to package or repackage, transform, wrap, roll, or otherwise encase. And then that is a $1,000 suspension fine, which also authorizes suspension or revocation of license. Essentially, again, you can't do pre-rolls. You're going to get your product for sale from at least from a processor. You're not doing it yourself. Let's see. Page 70, we make sure for legal protections, qualifying patient, et cetera, they can't be denied rights, privilege, et cetera, for possession. That is authorized by this title, as opposed to because somebody told them so. Changes on pages 71 through 73. We're striking all the contents of subtitle 13, the civil immunities and liabilities. And as far as why there were some of them, frankly, they can do it anyway, but this is custody and visitation. That's really more of an issue for judiciary. Some of the provisions relating to homeowners associations and that kind of thing may be more properly in either judiciary or ENT. And also my understanding is there are a few of these things where we fully expect the Senate to put them back in. So rather than strike the subtitle and renumber things, we simply give them a nice place to put it back. We call it reserved. And let's see, capital access program, starting at page 73. The changes really are on page 74. As it came in, the capital reserve program, the loan loss authorized $500,000 for a licensee. We've changed that. We kept it at $500,000 for the dispensaries, but for a grower or processor, we raised the cap to $1 million. Within the banking and insurance provisions modeled in the SAFE Act, there was a word, the federal language used, legitimate, that is not, we don't need because we already have a defined term that takes care of it. Let's see what else he is doing. Page 80 of the bill. This is the 1.5% distribution, tax distribution to the localities. We had to actually make it so that it's at 1.5% to the municipalities and then 1.5% to the counties for those areas outside the boundary of a municipality. We have additional language actually that will only be, funds will only be available to be used for behavioral health and drug treatment. And let's see, to continue, what else we got? Page 84. We don't do that. Okay. Page 85. Well, actually, it's following on later, page 84. These are the provisions I mentioned earlier regarding the executive director of the commission, the Alcohol, Tobacco, and Renamed Cannabis Commission, saying if he is a sworn police officer, he has law enforcement pension. If he is not a sworn police officer, he's in the regular pension system. Let's see. The page 86, lines 14 and 15, we, this is a transfer of merit employees from the old commission to the new commission, the new division. What? What?
Hold on.
No, I said 86, I didn't say 87.
Right, but there is no 86.
Okay, I'll just have to, I think that was a piece of paper that didn't manage to make it into the reprint. If that's the only one that's missing, that's great. No, I mean, in what, the photocopier. But,
So, I want to come back after we make that copy.
it,
So, was 86 missing?
okay,
We're gonna,
here's the one page. Okay.
you want to put a pin in it, wait?
Yeah.
We're just, wait 2 minutes, we're just gonna go make 25 copies for everyone, because, it did not make it through the copier.
Yep, it's not substantive, but
Page 86
there
was
is a
missing.
page 86.
It's blank on ours, but it's not meant to be blank, so.
Okay, at some point, if you want to
Yeah,
let me know when you.
when I guess whenever they're, you hit your button. Okay, hold on, you're right, you're right.
Okay, we're fine. I'll come back to page 86 when
No,
it's distributed.
They're just gonna bring it back in, we can just stick a pin in it, wait.
Yeah,
So
okay,
You don't have to come back, I don't want you to keep going.
okay,
Yeah, we're just gonna hand it out, we'll hit that one,
fair enough.
won't miss a beat.
Okay. There is a page 86, trust me. It's all uncodified, but there is a page 86. Mm-hmm. I made all the transfer. Yeah. I know. Okay, thank
If you go. There you go.
Okay, so as you can now see from the existing page 86, a change requested by the Medical Commission, lines 14 and 15. This is the transfer of merit employees. The bill as drafted said that was as of June 30, 2023. Instead, this is as of the effective date of the act, so that they can get up and going sooner. As soon as, this being an emergency bill, assuming it passes whenever it is signed, those employees immediately transfer to be employees of the new commission as merit employees without any loss of rights. Okay, starting on page 87. There is a provision here so that for a limited period of time through December, actually for a limited period of time, there is an exemption from procurement requirements for the commission. In this case, it adds to establishing a state cannabis testing lab at a pre-existing location so that they can actually get that up and going. The RFP process can be rather onerous. On the middle of page 87, actually, renumbered section 12, lines 16 and following, where the bill as it came in authorized one license for a Bigford v. Glickman plaintiff, and that's actually two licenses. It's one grower license that could then convert to or obtain an additional processor license. This makes it 5 Bigford or In re Black farmers plaintiffs who can acquire growers licenses and then subsequently apply for a processor license. So it's a total of 10 licenses. Page 88, and the top of page 88, and then you have unnumbered language for the next page as well. There are several studies that are being required. First of all, section 13 will require the commission to contract with an independent consultant to do a study on how we would regulate wholesale cannabis licenses, more comparable to what we do in alcohol, where we have the wholesaler, the distributor tier, as opposed to the processor, which is actually a form of manufacturer. And that's really looking forward to the time when, however slowly they move, the feds do actually eventually allow the interstate movement of marijuana or cannabis. We need to be able to have that system up and running, to much as we do with alcohol. Section 14, Medco is required under the bill to, well, it would be required to evaluate sites for proposed incubator space, and there are 4 different areas where they have to do that. The sites have to include proposed locations for incubator spaces, square footage, and estimated costs. We do require them to consider the suitability of converting to incubator space obsolete or underutilized commercial and retail properties, such as ancient malls, big box stores, and warehouse spaces, and then report back by January 1 of 24 to the General Assembly. Section number 15, we also require the Commission to conduct a study on on-site consumption of cannabis and cannabis products, essentially what other states and jurisdictions do in terms of authorizations and best practices, training requirements and safeguards, recommendations for policies, and include suggested regulatory and legislative changes. Again, that would be reporting back by June 1st, 24. Section 16 will require ATC to study various types of products and infused products that are not meant to be smoked, and they're available in neighboring states, or for example, DC, such as low concentration edibles, cannabis-infused soft drinks, and other beverages related products. How can we bring them into the state? How can we package, label, process, and make sure they're safe? So, and those are the all of the studies that require. And that, my dear friends, is the bill with the amendments.
Move the amendments.
Second.
Move the bill as amended.
Thank you, Mr. Chair. I promise you're going to enjoy this question. Council, you spoke when we did our first kind of hearing on this. We talked about where people can smoke in their house, etc. I didn't see any changes. Is that still, do HOAs still have to kind of provide guidelines for residents? How does that part work? Just want some clarification.
Those have been stricken by the House amendments.
Got it. Thank you.
Brief indulgence. Delegate Harrison, go ahead.
Just for clarification, so as of this day, this time, it is still illegal to smoke, and there are no on-site consumption smoking locations that are allowed as of today.
Great question, especially if you've been reading the paper. So we have local, this is why we actually have stepped in to the void here, because we have local jurisdictions licensing things that we believe the state should be licensing. So whether they're still legal today, we know as July 1st, they won't be, because it is the state's responsibility to push out these licenses. You get people to compete for these licenses, not just to hook your buddies up. So I can't tell you if they're legal now or not. I know that was never the intent for these things to happen, but I know under this new structure, they will not be able to be open unless they have a state-sanctioned license.
But right now, smoking marijuana is illegal.
It is.
Until July 1st.
Oh, without a doubt, yes, it is. I apologize for that. I thought you were talking about a very specific instance in Montgomery County where they opened up a public medical marijuana consumption bar without anybody knowing. But yes, it's still illegal. HOAs can still make whatever rules they want to make, things of that. So nothing has changed. Us voting this doesn't change that time structure that the great citizens of this state decided upon. Any other questions? Anger? There he is. Go ahead, Delegate Weibel.
Thank you, Mr. Chairman. Just clarification on page 39 where it talks about the those who hold licenses currently under the Medical Cannabis Commission. Are they then required to convert the license, or is that voluntary?
They are not. It's voluntarily, but here's the caveat. And it's a weird kind of voluntary system because they're not required, but there will no longer be a medical marijuana market after July 1st. Meaning, if they choose not to convert, well, they'll have a license, but they cannot operate. Again, they can sell to somebody else who can then convert without competing for that license space, but they themselves will not be able to operate.
So then basically they are being forced to convert.
No, because if they don't believe in recreational marijuana, if they have something in their morality that says, I believe in medical, I don't believe in recreational, they do not have to convert.
Okay.
But because it's a license, it's not a right, and we're changing the structure of how we're giving out, marijuana, giving out the product. We want to make sure it's accessible to as many folks as
All
possible.
right, so that wasn't the way I understood the previous version, but so basically if they choose not to get the recreational license, they're out of business as a medical cannabis
There will be
provider.
no such thing as just medical cannabis after the July 1st, correct?
Okay. Because I was thinking if they stayed as a medical license, they enjoyed a 6% price reduction because they weren't subject to sales tax.
There's that, I guess, that theory, but their market would dramatically decrease.
Correct.
So again, but the way we've set this up, because it's not a property right, if they choose not to participate, that's fine, but all of our cannabis stores will be selling both recreational and medical.
Okay, thank you.
And actually, to give, for clarification, medical product is still not subject to 20%, the sales tax. It's only the adult use, which is subject to the sales tax.
Correct.
So folks will still have a medical card,
Correct.
Yes.
Some
Those
of
who
them
have a
will.
medical card will not pay the 6% sales tax.
but they'll be buying it from a recreational.
There'll be, all of our recreationals will be required to not only have, obviously, medical marijuana on hand, but a fast track or some kind of system where they, like medical marijuana hours, where they can come in before the recreational people to get access to their medicine.
Okay, thank you.
Are there any other questions on this bill? Seeing none, the bill as amended was moved and properly seconded. Brief indulgence. All right, colleagues, apologize. I believe we're ready to get started. The motion is favorable. Delegate Crosby. Aye. Delegate Harrison.
Aye.
Delegate Boafo. Aye. Delegate Howard. No. Delegate Charkoudian.
Yes.
Delegate Rose.
No.
Delegate Pruski.
Aye.
Delegate Fennell.
Yes.
Delegate Turner.
Aye.
Delegate Sample Hughes.
Aye.
Delegate Valderrama.
Yes.
Delegate Chi.
Yes.
Delegate Frazier Hidalgo.
Yes.
Delegate Adams.
No.
Delegate Arentz is excused. Delegate Pippy.
No.
Delegate Jackson.
Aye.
Delegate Johnson.
Aye.
Delegate Rogers.
Yes.
Delegate Ampry.
Yes.
Delegate Weibel.
No.
Delegate Fisher is excused. Delegate Queen is excused. And the chair votes yes. 16 yea, 5 nay, 3 excused. The nays are Howard, Rose, Adams, Pippy, and Weibel. The bill passes as amended. Thank you, colleagues. We're just covering one bill today. Thank you for your patience and your time for this long process, and thank you for your input. See you tonight at the event if we can. Monday, because that's even more uncomfortable. It's even way worse, right? We do have bill hearings tomorrow, though, because Bob's angry with us. So, did you understand what she was saying? But